open your front door, but nothing's closed.
Yeah.
Like,
There's
jump on your
reasons why there's doors on the second floors of
Yeah.
buildings,
Yep.
you know? So that's kind of, I was there during the best time of year.
Yes.
All right, what are we going on?
I believe Mims and Finesca Figueroa will be relatively short.
Yeah.
If
All
you
right.
want to start with those, Strong
do
is going to be a whole
Mims.
thing. I will go grab Mr.
It's 17. All right, so we're on the record in docket 22-03411. That is people of the state of Michigan versus Dominic Mims. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Mims, who is present, standing to my right.
And sir, you are Dion Mims, is that correct?
No, sir. I thought it was going to correct it the last court date.
I may have said that and forgot. It's Dominic Dion Mims.
Yes, sir.
I remember. Let me make that. Somebody, we've got your middle name only.
Yes, sir.
All right, Ms. Wilson, this is the time set for final pretrial. How are we proceeding?
Thank you, Your Honor. The complaining witness in this matter was subpoenaed. She has not appeared today. We have had contact with her. It has not been fruitful. I expect a motion from the defense.
Ms. Wicks.
Defense would be asking to have this matter dismissed.
All right. So we will print out a nollie pros for the prosecutor unable to proceed. I'm going to grant the motion to dismiss brought by the defense. That'll be without prejudice. So does she have that up there? Usually Wendy prints the dismissal.
Right, we're getting it.
Okay.
Yeah.
And Shelley.
I know everybody's different, so I'm just double checking.
JHG, he's got a tether.
Oh, and he's
Yeah,
got
got it.
email, GPS. Yeah.
Yes.
Okay.
All right, so I will sign, first of all, I will sign the order to dismiss without prejudice, which means that the people may reissue if they choose to, but realistically, for our purposes, the case is dismissed today. We will also email the JSG for your tether, and then you can get that taken off. All right. I would wait about a day for it to purge from the system, because you're still in the computer system, and you want to make sure that violation isn't a problem.
Yes, sir.
Anything else for the record? Do you have any questions of me, Mr. Mims?
No, sir. Just better be free.
All right. Anything else for the record in 22-03411, Ms. Wilson?
Half of the people.
Ms. Wicks?
No, thank you.
All right, Mr. Mims, I'll sign that as soon as I get it. You're all set. Thank you for your
Yes,
appearance.
sir. Thank you. Madam Chairman.
Yeah.
Vanessa,
Yeah.
next. Okay.
I did not ask for it.
Yeah,
Oh, I'm sorry, Judge.
yeah. So
Sorry.
I'll put on here at the request of defense.
Yeah,
So we usually do
it's an.
it says acquittal on it, but it's a
acquittal
motion from the
slash
defense.
Dismissal
Yes.
slash
You want me to
remand.
execute it? Judge?
Yeah,
Let me do that.
let's do that. Because that says on it a defense motion
Yeah.
to,
It
Yeah,
does.
and then
then I'm not.
then you're
on
not in
it.
the, I get it.
And it's an accurate reflection of what just happened.
I never motion. I understand the court in very limited situations actually has the power to grant a motion to dismiss. I wasn't asked.
Yeah.
This is the defendant's motion, right, Judge?
It's the defendant's motion to dismiss.
Gotcha.
It's all semantics, but
Yeah.
it
Yep.
matters later.
Yeah.
We used to do the same. That was, it reads a little better. All right, the case defendant's motion to dismiss is granted. I will sign it. And David, do you want this, or Shelley, do you want?
Oh, I'm gonna make him a copy.
All right.
Yeah.
And this is Mr.
Finesco Figueroa.
Panesca Figueroa. All right, so we're on the record in docket 21-00183. That is people of the state of Michigan versus Salvador Finesca Figueroa. Will the parties please introduce themselves for the record? Ms. Wilson.
Go Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Finesco Figueroa, who is standing next.
And sir, you are Salvador Finesca Figueroa?
Yes, sir.
Thank you. This is the time set for a final pretrial today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness was here earlier. He is not willing to participate in this matter. Without his participation, people cannot proceed. I expect a motion for the defense.
With that being the case, defense would ask to have this matter dismissed.
So once again, I will have the dismissal. I will be in possession of a dismissal or nollie pros made by the motion. It's granted. Defense's motion is granted. So this will be granted without prejudice, which means the people could reissue if they choose to, but realistically today, the case is dismissed. All right, sir? All right. Right, so I will sign the motion to dismiss. Anything else for the record in 21-00183, Ms. Wilson?
Not for the people.
Ms. Wicks.
Not for defense, thank you.
All right, Mr. Fonseca Figueroa, and that's Figueroa with a D, right?
With a T?
With a D or a T?
Oh, no, D. F-I-G-U-E
R-E?
R-E-D-O.
D-O, Figueroa.
Figueredo.
Okay. Figueredo, all right.
Figueredo.
You should be all set, sir. Your motion's been granted. Thank you for your participation
Thank
today.
you.
All right.
Thank you. sir. Have a good day.
You too.
Thank you.
Ms. Sutter, did you have a nice time in Colorado?
I did, Your Honor, thank you.
The smartest thing you did was come back with not a lot to do today because that would be no way to start your break.
Yeah, the heck of a start.
Well, that sounds, you were missed, by the way.
Thank you.
Not that we,
Very nice.
not that we didn't enjoy Miss Wicks always and Mr. Lead covered, but it was, you were missed.
Thank you.
Ms. Wilson, where did you want to go now? And we don't have to go anywhere.
Right.
No, I'm, oh,
You are both, okay.
Sit up here.
So, Ms. Sutter, where did you go in Colorado?
my end goal was Durango, so I spent a few days there, but I kind of wandered through Loveland, down to Denver, Colorado Springs, then over to Durango.
Okay, so that, yeah.
Yeah.
And Durango's far from Colorado.
Yeah. it's-
Durango's far from Denver. It's, you know,
Yes, I was about 5 hours south to Colorado Springs and then 6 hours west to Durango.
all right. And if I remember, Durango had a pass by it.
Yes, it does. And I was going there to ride a train.
All right.
So, yeah, I was
It's where I've got friends who ended up moving to Durango
Yeah,
for
right now.
college
Yeah.
and then just stayed there. They stayed, they just loved it.
It was a nice, I really
Beautiful.
liked it.
Yeah.
I liked the southern half of the state. Well, the northern half was nice too, but I spent most of my time in the southern half.
In the southern half of the
I
state.
liked it, yeah.
Yeah, I've only been to Durango a couple times, but they've been there for 30 years. They just loved it. So
It's the kind of heat I can tolerate. I don't do well with humid heat. Dry heat, I'm okay.
it's supposed to get hot here.
It's only about-
Little,
supposed to be
It's
in the 90s and
it's
stuff.
supposed to get, you know,
like 95.
like, yeah, the 90s, but
95 with 60% humidity is a lot different than 95 with 2%
yeah,
humidity.
I agree. It's all hot. I mean, you know, an oven's hot,
Yeah,
but it's for some reason having to get out of the shower and take a shower. It's just, you know, when you get out of the shower and you feel like you need another
Yeah.
shower,
Yeah.
there's something not good about that.
Have anyone on Zoom besides Mr. Strong?
Yeah, Mr. Strong. Oh, no. Oh, yeah. Let me let everybody in. Mr. Yang's there.
Okay, we could probably go on Mr. Yang's
Mr. Hanks,
case.
that he's got Mr. Hanks. Mr. McConnell.
yes, Gage McConnell, he's here for 9 o'clock.
Mr. Yang, you're here on Mr. Hanks.
Good morning, Your Honor. That is correct.
All right, is Mr. Hanks here or?
I don't think so, but this is just gonna be a joint request for
All right.
adjournment.
All right, let's call that. So, Mr. Yang, let's call your case.
Thank you, Your Honor.
All right. So we're on the record in docket 24-00275. That is people, the state of Michigan versus Javon Hanks. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Yang.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Javon Hanks. He is not present, but I'm waiving his appearance for today's hearing.
All right, and Ms. Wilson, you're also waiving Mr. Hanks' presence for today's hearing, is that correct?
I am, Your Honor.
All right. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Hanks has a date set, I believe the 24th, in 55th District Court. The resolution on that case will ultimately impact the resolution on this case, as there is a global offer in place. So I believe we're going to be requesting an adjournment to after that date. And obviously, if the agreement comes to fruition, I can submit a nollie process to that fact.
And that's a fair statement, Mr. Yang?
It is, Your Honor.
So we would adjourn to sometime after June 24th. All right, so we'll adjourn for global resolution sometime after June 24th too.
We have Mr. Chapman.
July 8th. So we'll set it July 8th at
8:30.
8:30. Perfect.
That works for me, Your Honor. Thank you.
All right. Will that work for your schedule, Mr. Yang?
Yes, Your Honor.
All right. So we'll set it for July 8th at 8:30. Anything else for the record in 24-00275, Ms. Wilson?
After the people.
Mr. Yang.
Nothing on behalf of defense, Your Honor. Thank you.
All right. Thank you. You're all set. Thank you for your appearance today, Mr. Yang.
Thank you, Your Honor. Have a good one.
You too. Sir, in the Ingham County Jail Post 2, would you identify yourself?
Sean Bill
That's who
Chapman.
you're- Perfect. Thank you, sir. All right, so we're on the record in docket 24-01315. That is the people of the state of Michigan versus Aaron Pope. Parties, please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Pope, who's present standing to my right.
And ma'am, you are Aaron Pope, is that correct?
Yes.
Thank you. This is the time set for a pretrial, final pretrial in the matter. Ms. Wilson, how we proceed?
I think, Your Honor, I believe this is going to be requested set for a jury trial. I don't think there is one set yet.
All right. So this is a request for jury trial. At the final pretrial, is that a fair statement, Ms. Wicks?
It is, Your Honor.
All right. And I don't know what date, when did July. Okay. We'll set it for July 15th for jury trial at 8 o'clock. Both parties know that the jury instructions are a week before or in that vicinity. And that'll be live in person at Ms. Pope. All right, ma'am? Anything else for the record in docket 24-01315, Ms. Wilson?
After the people.
Ms. Wicks?
Not for defense, thank you.
All right, we'll see you on July 15th. Thank you for your appearance today, ma'am.
wish they would have told us having court. It'll just be having the time of their life.
Somebody was at court.
So I'm in court. I'm in court.
Mr. McConnell, yes, you are. We can all hear you. So you may want to mute or not talk.
I'm so sorry.
No worries. Thank you. All right, so we're on the record in docket 24-00753. That is People of the State of Michigan versus William Strong. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Strong. Mr. Strong joins us via the Zoom application.
And sir, you are William Strong, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Mr. Strong?
Yes, Your Honor.
All right, thank you. This is the time set for some motions in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think if we want to start with the people's motion, I believe there is a stipulation. And the stipulation is that the ultimate findings and disposition of the CPS investigation would be excluded. The CPS worker can testify as to, what occurred during their investigation to the extent the rules of evidence permit, but the ultimate conclusions would be suppressed.
All right, and that's your understanding, Ms. Wicks, that any conclusion that comes out of a report concerning any investigation that CPS did would be excluded, and then the rules of evidence would apply as always to whatever social worker takes a stand.
Correct.
All right, so with that stipulation, we'll stipulate to, I don't know what to call this. It's a pretrial discovery motion, I guess. Yep, yeah. Pretrial motion to suppress any findings of CPS that comes out of the report.
Mhm.
Excuse me, Your Honor. What is that? What exactly is that motion?
It's a motion. It's a motion by your defense lawyer that she's requesting that any by the prosecutor. It's a stipulation between the parties that any previous investigation done by CPS not be admitted, only the testimony of the worker, and she'd be subject to any rules of evidence.
Meaning that any cases that we had from CPS before this case aren't able to be used, basically?
No.
They wouldn't.
No, just that only what comes out of the reports. Anything that they decided is not available. I'm not sure about the prior contact.
I don't have any of the prior contact reports. I'm
All right.
intending on
All right.
using them.
So that I would think
Just
that would be
the
character
ultimate
evidence.
conclusion
Right,
is
yeah.
not being allowed.
So the rules of evidence would not permit some of the character stuff. This is the ultimate conclusion in the investigation done. I would think for your purpose of not having any of that to be relied upon by law enforcement in this proceeding. That dismissal, so that suppression is to make sure that no previous investigation gets in by
Quite, Your Honor.
CPS.
The motion was specifically to the incident, to the investigation that arose out of the incident,
Out of this
underlines and
incident.
charges.
Out of this incident,
And
and
it's-
only the ultimate conclusion
Right,
of that.
so whether or not it was substantiated,
Right.
that kind of thing.
Yes.
Right. So it's my understanding CPS did their own investigation in this matter.
Correct.
Is that correct, Mr. Strong? That
Yes, Your
all
Honor.
of that investigation and whether it was justified or not, that's going to be left out. That investigation on this file.
Just the conclusion.
Okay, just
The actual investigation, subject to the rules of evidence, can be admitted
through the testimony.
CPS worker,
All right.
yes.
So the conclusion of the ultimate conclusion that CPS reached is left out the worker is going to testify.
I'm not understanding why they would leave why would you want to leave a CPS conclusion
Mr. Strong, I
out?
can meet with you in a breakout room in just a minute and explain to you
Okay.
better.
So your attorney will meet with you, but that's the substance of this first motion. And then you can meet with your attorney in order to get an explanation as to the motion. Okay, sir?
Okay.
All right. So that's the first motion.
And does the court want me to submit an order to that effect?
Yeah, if
Okay,
you
yeah,
would,
just so we have it, yeah.
Yeah, and that would clarify any notes that I may or may not have made. Do you have any, was there a second motion?
There was a second motion, it is brought by the defense, so I will let them be.
All right, second motion by the defense.
Thank you, Your Honor. This is a motion to exclude some text messages that were included in discovery. Your Honor, I don't want to belabor my brief too much, but the defense's argument first and foremost is the text messages are not relevant, as they do not have a tendency to make a fact more or less probable than it would be without the evidence, and that they are not in consequence of determining the action. This is because one, there are no statements in any of the text messages about any assault, any intent to assault. There is nothing regarding intent. They are also, if the court decides them relevant, I would also be making the argument that we don't know who they're sent to or from, or when they were sent, as there is no identifying time or date on these messages. These messages could have been from months prior. And if the court still decides they are relevant, they are not probative of any relevant fact. Again, the messages do not show how he intended to grab or assault anybody in this nature, as would be required to show the mens rea. And it does not tend to make any evidence of an assault more or less true. Not probative of his mens rea, because it would reference some sort of assault or physical contact if it were evidence of the mens rea. There was nothing about, trying to get his hands on his son. There was nothing about assaulting his son. These were simply conversations between parents, and parents vent and speak differently to each other than the children. And he was expressing frustration. And so these are between the parents. This has nothing, while the content of the text messages may have to do with the son, it has nothing to do with the alleged assault in this nature. And even if the court still finds it probative, it still has to overcome the prejudicial effect. And Your Honor, just simply the nature and number of them is likely to be more prejudicial than it is probative to any fact, as it is defense's contention that they are not relevant to whether or not assault committed. And even if they are, they would be more prejudicial than probative.
All right. And then how many, and this was provided to you in discovery, is that correct, Ms.
Correct.
Flores? How many text messages are we talking about?
I believe 3 pages were 5 pages. 5 pages.
Ms. Wilson, response.
Thank you, Your Honor. Before I begin, I submitted my response rather late on Friday. Has the court had the opportunity to review it?
I have
You
not.
have not, okay. So
have
then
not.
I unfortunately am gonna get into the weeds here a bit.
Okay.
So the defendant is currently charged with child abuse in the 4th degree. One of the elements that the people would have to prove at trial is the mens rea. Child abuse in the 4th degree is a general intent offense. We are using the theory that the defendant knowingly and intentionally committed an action that posed an unreasonable risk of harm to the child. In order to determine the mens rea, the act by the defendant must be done knowing or intentionally, but he does not have to know or intend that the action poses an unreasonable risk of harm to the child. The text messages that the people intend to submit as evidence are circumstantial evidence of the defendant's mens rea at the time of the offense. Under People versus Hoffmeister, the mens rea may be inferred from the defendant's conduct, judged in light of the circumstances. It's my understanding that these text messages occurred the night before the incident and into the next morning. And Ms. Porter, who received the text messages, can testify as such. the statements that were made in the text messages are indicative of the ire that Mr. Strong was feeling towards the child leading up to the assault. Incidents rarely occur in a vacuum. Often an event is connected with some antecedent event from which the fact or event in question follows as an effect from a cause. That is People versus Delgado. So we have here basically Mr. Strong getting upset the night before at the child, sending these text messages to the mother, and in some of the text messages telling the mother to tell the child the things that he is saying. And then he goes to the house, they sit down, they talk about these text messages and the circumstances surrounding them. Things get even more heated and this assault occurs. I think that's highly probative of his mens rea and his state of mind at the time of the offense. And it also gives substantial context to how this assault came about to be. So I think it's something that the jury needs to know in order to understand his state of mind and also the context of the situation.
And of course, but in any child abuse case, so it could be an accident.
It could be.
Or it could be effective and legal parental discipline.
It could be, Your Honor. And People v. Green ruled that the welfare of a child is the principal ground on which the parental right to chastise him is founded, and where the punishment inflicted is so excessive and cruel as to show beyond a reasonable doubt that the parent was not acting in good faith for the benefit of the child, but to satisfy his own evil passion. He no longer is to be considered as a judge administering the law of the household, but as to a malefactor guilty of unlawful assault upon a helpless person, instructed to his care and protection. I think if he's going into this saying these things about the child, saying that he hates them, that he wishes he was never born, and having these issues with this child, it's a pretty good indicator that he wasn't acting within reasonable parental discipline. He was acting because he was upset with the child, he was mad at the child, he was not acting in a parental role. He was acting out of anger, he was acting out of frustration. So it is also a rebuttal to the defense's possible position of parental discipline. And I think that it needs to be introduced for that rebuttal.
And the defense has to make, no, they don't have to put anybody on the stand. This is
correct. Yes.
They have no burden here. Ms. Wick's response.
Thank you, Your Honor. The people do cite People v. Hoffmeyer in their response, which says the requisite state of mind may be inferred from defendant's conduct judged in light of the circumstances. What I'm highlighting is such an inference, however, must have an adequate basis in record evidence. There is still no record in that text message that makes an assault more or less likely to have occurred. While there is venting and frustration, there is nothing in the text messages that say anything about an assault, a plan to assault, any violent language at all. And so, Your Honor, I would still make the argument that it is not probative of anything because there is nothing regarding an alleged assault, especially with the timeline that if it was the day before into the morning of this is alleged to have occurred the next evening, there would have been plenty of time to cool down in between the two. So even if there was a frustration the night prior, when this is alleged to have occurred, there was also...
Your lawyer speaking, Mr. Strong.
There was also a cool down period in the interim. And so, Your Honor, I would ask that the text messages be denied.
All right, thank you.
Your Honor, if I may, I think that's really conflating mens rea and the inference in Hoffmeister here. If somebody is charged with premeditated murder, evidence of somebody's premeditation can be inferred from them picking up poison, doing things like that. It doesn't have to be a text message to someone saying, I'm coming to kill you. It doesn't have to be an explicit statement of what they intend to do. It can be inferred from everything surrounding it. And I would also point out that this isn't just as to mens rea, this is also a rebuttal to a defense and context for the situation. While there might have been a cool off period, it's still incredibly probative of the mens rea of the situation. And I will point out that 403 requires that the prejudicial value be substantially outweighed by the probative value. The probative value here goes to the essence of the case, the mens rea, an essential element of the case. It is highly probative. And while I'm not disagreeing that the text messages aren't possibly inflammatory. They're not great. It doesn't outweigh the probative value and the ability for the people to make their case. There isn't really a better way for the people to show the intent, show the knowledge, show the state of mind of the defendant, other than those text messages.
Thank you.
Your Honor, if I may, what's being said
You,
isn't.
Mr. Strong, you may not want to. You may not want to say anything about the case.
Would I be able to speak with
or
my
the
attorney
facts
in
of
a
the case.
breakout?
You have a lawyer, and so and your lawyers made an argument to suppress these coming in. I'm not sure you want to say anything because you're on the record and anything can be said. Anything you use can be used against you.
May I
and Ms.
speak
Wicks
to
is
them in a breakout? 'Cause I
Yes.
haven't been able to do that.
Yeah. So Ms. Wicks, it sounds like your lawyer would like to talk to you. You're a client, which would probably be a good idea, and then we'll put it back on the record. Okay. So Mr. Strong, I'm gonna have you placed in a breakout room. Let's put you in breakout room 1.
Thank you.
And I'll put your lawyer there, and then once you're all set, we'll put it back on the record. All right, sir? And once you join us, Ms. Wicks, we'll.
Judge, I got a question. Sure. So, Jarvis Lewis, he's been here this morning, but Mr. Eastley hasn't appeared yet. He called him and I texted him. I haven't got a response yet, but Mr. Lewis has been here. He's been calling too to see if he was still coming or not, but I didn't know if he wanted.
Unless we hear differently, they're supposed to come.
We've never even gotten an appearance from Mr. Easterly, as far as I can tell. I have no
We have an
idea.
appearance from Mr. Easterly?
So he doesn't have discovery. I don't know what's going on with that one.
Yeah, he can show up and explain why there's no appearance or anything
Okay,
by Zoom. That's a final pretrial, but yeah. But Mr. Lewis is supposed
There
to
was
be
an appearance filed in May.
from Mr. Easterly.
Okay,
Yeah.
so for some reason our office must have not received it.
Does he have discovery?
No.
I'm sure he wants discovery before. Yeah.
I said we haven't heard anything.
Nothing.
No.
All right. I mean, we
Yeah.
can reset it.
Yeah, have him join us and we'll
Okay.
put it on the record.
I'll bring him in here.
Yeah.
Yeah.
Or Mr. Lewis, right?
Yeah, Jarvis. Davis.
Well, you guys were here on 6/3 for his pre-trial.
Yeah, and I didn't have an appearance then.
There's Miss Wicks. I'll put Miss Wicks in room 1. Would the individual on Joe's S22 please identify yourself? Joe's S22.
This is Joseph.
Not here the last.
What's your last name, sir? Your last name? Joe? Joe Brinson?
Yes, sir. It's
All right. You're here for your 9 o'clock?
Yes,
Joe
sir.
Brinson? All right. And you are not represented by counsel today, is that correct?
That's
Or are you
correct.
represented?
I tried contacting O'Keefe Law and also Grable. Grable gave me a quote of $3,500, and that's a
All
little
right.
high for me.
Stand by. I might have you talk with the assistant.
I've spoken with him and I have his email. I was trying to figure out how to get discovery to ProPERS. Now that I know how to do that, I can send him that information.
Does he have to file an appearance on his
He
behalf?
would, yes. Mhm.
Yeah. All right. Do you want to tell him that?
I can
think he's
email
got
it to him.
Yeah.
Yeah.
All right. All right. Let's go ahead and call your case on the record, Mr. Brinson. So we're on the record in docket 21-00662. That is People of the State of Michigan versus Joseph Brinson. Ms. Wilson, your appearance for the record.
Abigail Wilson for the people.
And you, sir, you are Joseph Brinson, is that correct?
Correct.
All right. And you can hear me all right, Mr. Brinson?
Yes, sir.
All right. And it's my understanding you are not represented by counsel today, and you've reached out to several counsel in order to retain counsel. Is that correct?
Yes, Your Honor.
All right. In the interim, so this is set for pretrial today. In the interim, you've had some contact with the assistant prosecutor. Do you plan to be represented in future events to seek, or are you going to represent yourself?
I would really like to have a lawyer for future events. Did you say that the prosecuting attorney contacted me, you said?
We spoke in a breakout room at the last pretrial.
Yeah, and my understanding is you did you apply for a court-appointed attorney and then you were denied by the public defender?
Yes, sir.
All right. All right, so if you, in the interim, I know the prosecutor's office waits for an appearance in order to file discovery, all right? And nobody's, go ahead.
It shows on the electronic ROA that he denied.
Yeah.
Request that he denied to apply.
If I
Correct.
recall correctly.
Which he's allowed to.
If I recall, it's because he thought that he didn't qualify.
Right. So Mr. Brinson, you've never applied for a court-appointed attorney. You indicated you did not want a court-appointed attorney because you felt they could not represent you because you made too much money. Is that correct?
Yes, Your Honor. At my arraignment hearing, I talked to a gentleman, and he said that I made too much money, and that it's not even worth a shot. But if things had changed, then maybe I could retry.
All right. Well, let's do two things here then. Let me give you the number to the public defender's office because you can always reach out. But I don't know if your finances have changed at all, but they have. They may be able to represent you. So I'll give you that number. In the meantime, what you're going to have to do if you want discovery for yourself is to file some type of an appearance with the court indicating that the discovery should be sent to you personally. That's really just to protect where your discovery is sent. Since you don't have a lawyer, your lawyer, if you had a lawyer, say Mr. O'Keefe, he would file an appearance on your behalf and then discovery would be sent to him. They're just very careful about sending out your information, your discovery information. So
yes.
do you plan to get a retained attorney to represent you in the matter? And we can adjourn this for that. That was on May 28th, but you're running out of time, Mr. Brinson. You have to get a lawyer here at some point in time.
Yes, sir.
Or represent yourself.
Yes, sir. If it's okay, if I could try to get O'Keefe on board.
Okay.
I received a call back from a secretary that he was busy and he'll have to get back with me. My son's birthday was just recently, a few birthdays, and it was just, I have no excuse for not having a lawyer right now, but if you could grant me that'd be great.
I will, but this now takes the highest priority. This takes the highest priority because you can't show up at the next pretrial without a lawyer. We're just going to set it for trial at that point in time. And that's where this all gets really kind of hairy because that means that you need discovery. So you're going to have to file an appearance on your behalf. So discovery will be sent to you, things of that nature. So let me give you the PD number just in case. The public defender number is 517.
Your Honor, could I grab a pencil real quick?
Sure, sure.
Okay, thank you.
You're welcome.
Well, actually, I could just put it on my phone, I think.
Either way, just as long as you take down the number, you should be fine.
Okay, I'm ready, sir.
517 679
679
2979. You can always attempt to make application to them. They may still be under the guise that you financially are not able to be represented. So you might have to go the Patrick O'Keefe route or the retained attorney route. But I will adjourn this to another date. I'd probably 2 to 3 weeks out.
July 8th at 9:30.
So I'm going to indicate that defendant's not represented at this time, is seeking counsel. Seeking counsel. And we'll reset this for July 8th at 9:30. Great.
Yes, sir.
Okay. 9:30. So we'll reset this for July 8th at 9:30. Now, if you show up without a lawyer on July 8th at 9:30, we're just gonna set it for jury trial at this point, because this gives you some time and you're running out of time, all right? Mr.
Yes.
Brinson?
Yes, Your Honor.
All right, and so I would think that you won't be getting this, we won't be filing an appearance until your lawyer files an appearance, and that's what the prosecutor's office is waiting for, an appearance to be filed so they can send out your discovery. All right, sir?
Yes, sir. Yes, Your Honor.
All right.
May I ask a question? What a
Sure,
discovery?
you can ask a question about the process, just don't say anything about the facts.
Okay, I was just wondering, the discovery, is that the whole case, I guess, is that,
The discovery would be the police report and anything that was used in order to file charges against you.
okay, understandable.
All right. All right. So you'll get notice sent to that Kenwick Circle address. Is that still a good address for you?
Yes, Your Honor.
All right. Anything else for the record in docket 21-00662, Ms. Wilson?
After people, thank you.
All right, Mr. Brinson, we'll see you on July 8th at 9:30. That'll give you some time to get a lawyer and get discovery, and the lawyer can file an appearance. All right, sir?
Okay, thank you so much, Your Honor.
All right. Have a nice day, Mr. Brinson.
You too. Thank you, sir. What do I press to leave? I just hit leave at the top?
I think leave, yeah, just hit leave.
Okay. All right. Thank you, Your Honor.
You're welcome. All right, Miss Lee, you can unmute.
Hello.
Miss Lee, are you represented by counsel today?
No, I'm representing myself.
All right.
That's fine. No.
All right. And so we're on the record. I'm going to call your case. We're on the record in docket 21-01534. That is the people of the state of Michigan versus Dasha Lee. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And ma'am, you are Dasha Lee, is that correct?
Correct.
All right. And you can hear me all right, Miss Lee?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. And Miss Lee, first of all, you are not represented by counsel. You are representing yourself today. Is that correct?
Correct.
All right. This is the time set for pretrial. I don't know if discovery's been sent out in this case.
It hasn't, Your Honor, but I think what I'm gonna say is possibly a resolution.
Okay,
to that.
all right.
Previously, Ms. Lee had indicated that she had relinquished the dog to animal control. I did follow up with that. They indicated that the dog wasn't with them, but that quarantine had been previously done. So Ms. Lee is currently in compliance, and my understanding is the dog has been relocated to another home. So the people would be asking to dismiss for compliance.
All right. So Ms. Lee, did you get all that? The people are moving to dismiss for compliance purposes without prejudice.
Thank you.
All right, so I'm gonna have that'll be a nollie pros. So I'm gonna have that printed out. That'll be a nollie pros will be printed out. That'll be dismissed without prejudice, which is the default form, which is the default matter. So this case is dismissed without prejudice, which means the people could reissue if they choose to. Realistically, they're the ones motioning to dismiss without prejudice. So I don't think that they'd be reissuing. But you should know that it's dismissed without prejudice today. You understand that, Ms. Lee?
Yes, sir.
All right. I will sign that order to that effect. Is this on a complaint or a?
I believe it's a complaint.
All right. All right, I will sign the nollie cross to that effect. This is dismissed for compliance purposes. You should be all set, Ms. Lee.
Thank you. Have a great day.
You too, thank you. Thank you, Ms. Wilson.
Thank you. Okay. No, because he got out of ICJ and we didn't know.
Oh. It wasn't great nothing about what happened. I kind of suspected maybe something like that.
Yeah,
Or bad
mhm.
news. I do have a new this room, so.
Okay.
He is here. He's the
Okay,
gentleman
cool.
in the wheelchair. So I think this is a good job.
Yeah, mhm, yeah.
You, when you give that to David.
Oh, okay. Was that by animal control or?
That would have been a great clarifying question for me to have asked.
Yeah.
He told me that, wouldn't it? Oh, no.
Okay.
Okay.
Yeah, that was my assumption.
All right, Mr. Lee, you can come up here. Mr. Lewis. Mr. Easterly filed an appearance on your behalf. Is that correct? He's not here right now. Did you want to, we've had some, I'm uncertain he knew whether he was supposed to be here or not.
It's hard to say. He's the prosecutor over in 54B right now, so it's kind of hard to tell what he does or doesn't know about the scheduling in 54A.
Let's reschedule.
Yeah.
Okay.
Do you know what it is?
Mr. Easterly is the city
He's on the contract to be the
with the
city
city attorney.
prosecutor for 54B.
Why don't we reschedule, all right? And then that way, Mr. Easterly would have all your discovery on the case and we'll go forward. And then we don't have to hold anybody. I just don't know if this made it a Mr. Easterly schedule or not, okay? All right, so let's go ahead and call the case. So I don't know why I just motioned you to stand up because you always stand up. So we're on the record at docket 2400956. That's people of the state of Michigan versus Jarvis Lewis. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lewis.
James Lewis.
All right. This is the time set for a final pretrial today. It was also set for jury trial on the 8th. So Ms. Wilson, how did you want to proceed today?
Thank you, Your Honor. Mr. Easterly is not here today. It's possible that this didn't make it on his schedule, so I believe we're going to be asking to reset this. I'm not sure about what date it would be reset for, so I don't know if we're going to run into an issue with the jury trial.
I would think that we just reset the final pretrial for the date of jury trial.
That works for me.
I think that that would be, the rescheduling is to treat that jury trial date as a final pretrial date and have Mr. Easterly contact you.
Mhm.
And then that would be that he'll get notice of this. You'll also get notice sent to the Gun Road address. Is that still a good address for you? All right. So I'm going to indicate Mr. Easterly is not present, but the defendant was. And we'll reschedule for final pretrial July 8th at 8:30. You'll get notice from the court, my court officer. So Mr. Lewis, that's the date set for final pretrial. We've rescheduled it. That'll be on that will send notice to Mr. Easterly, and then we can go from there after Mr. Easterly and Ms. Wilson speak, all right? Anything else for the record in docket 2400956, Ms. Wilson?
Not for the people.
All right, Mr. Lewis, you might want to contact Mr. Easterly, keep in contact with him, just to make sure that this is on his radar and that he definitely has the schedule. I think he's in the East Lansing District Court today.
That's what I was thinking.
All right.
I sent him a text about it yesterday.
All right.
If we still have court today, but.
Yeah, so just contact him, all right? You should be all set. Mr. Lewis, do you have any questions of me? All right, thank you. You're all set.
Thanks.
And then Ms. Wicks, are you ready on Mr. Strong?
I am, Your Honor.
All right. All right, Mr. Strong, we're gonna recall your case. All right, thank you. So we're on the record in docket 24-00753. Ms. Wicks, did you have the opportunity to speak with Mr. Strong? Just to explain, we're on Zoom here.
Yes.
So Mr. Strong's on Zoom. Ms. Wicks is here. You had the opportunity to explain some of this motion work to Mr. Strong. Is that correct?
Correct.
All right. Anything else to come out of before the court makes their decision? I'm going to make a partial decision on this. So I do find it's relevant, okay, and mostly because it goes toward there is information that may be seen on this that may go to mens rea. I understand the prosecutor has to prove it is not appropriate corporeal punishment, and the defense has to prove nothing. So that burden's on you, and part of that is mens rea. Part of that is that the amount that you're disciplining the child. Things of that nature, and that goes without the defense proving anything. Now, so I find it's relevant. Relevance is a pretty low standard under the relevance test, and I think this can be taken into mens rea. It's true this doesn't go directly to the assault, but it may go to the mindset which you have to prove in regards to the corporeal punishment. So I do find it's relevant. Now, to me, the more important factors under the 403 balancing test is how many texts is necessary to make that? Because do you need all the texts, or do you need just a couple of texts in order to argue that he had a different mens rea than to abuse than the corporal punishment? And I think that can probably be taken care of day of. As I look at the text, and we'll decide, and we'll pare them down. I would treat this like autopsy photos. You don't need all 15, you just need 2 or 3, So the first was a stipulated to, the second is I do find it relevant, and then I'll hold in abeyance what that means in regards to how many texts can come in. You still have to follow the federal rules of, or the Michigan rules of the MREs as opposed to the FREs. The MREs in regards to you have to lay foundation for each text, things of that nature. Of course, they just aren't admitted in a vacuum. So we will find that it is relevant under the it is relevant, but we will hold in abeyance the amount of text for 403 balancing purposes, and then we will wait on day of trial to decide how many should come in. I want to, I'd have to look at all 5 texts, but in fairness, only a couple of them would probably come in, assuming you laid all the foundation for them.
Would the court like me to include that in my order on the other motion as well?
However's easiest. Okay. If it's easiest for the court to see that, because I'm not the fact finder, the jury trial is, so they can and then consult with Ms. Wicks on it. But you understand what I'm looking for.
I do, yes,
yeah. A minimal amount to show the relevance, and that you still have the rules of evidence to lay as foundation for each one. So that's the ruling. You can follow it up with an order, Ms. Wilson. Anything else for the record in 24-00753, Ms. Wilson?
Briefly, Your Honor, there are 2 minor children that will be testifying. I've spoken with Ms. Wicks, and I think we've agreed that there will be a closed courtroom while they're testifying.
All right, and what are their ages?
10 and 12, about to be 13.
All right, so closed courtroom is and we won't live stream that.
Yep.
Yes.
All right.
I think.
All right, and we have reset, so we've used this as the motion day, which is a good idea.
I think we've had a couple of final pre-trials, so I think we're ready to just schedule a jury
All right,
trial.
so whatever July date we have for jury trial. I don't know, I would think that this is a 24 case.
Yeah, and I am looking at probably 4 to 5 witnesses.
All right, so maybe a day for sure, maybe.
Yeah,
into
maybe
the next
another one, yeah.
All right. I don't know what she's got for jury trial day in July.
I just said that Aaron Pope on July 15th. We have 5 others on July 8th. If we put this in with Aaron Pope on the 15th.
Yeah.
Yeah, that's fine.
And then I'll block that day.
All right. So July 15th at 8. So Mr. Strong, we've set this for July 15th at 8 o'clock for jury trial. That'll be live in person on the 6th floor, City Hall of Lansing. Anything else for the record in docket 2400753, Ms. Wilson?
Not for the people.
Ms. Wicks?
Not for defense, thank you.
All right, Mr. Strong will be live in person on July 15th at 8 o'clock.
What
That's all
was
for the
I'm
record.
not understanding what was the ruling for today for the both motions? What was the verdict for the ruling for both motions?
So-
Go in a breakout room.
I'll email you what just happened.
Yeah, in regards to, there was a stipulation for, which is pretty solid in regards to no investigation of the summary of the conclusion done by DHS. And then this one, I've ruled that some of the text messages may come in because they are relevant, but the amount will be decided day of trial.
Okay, so for that first one with the conclusion, that was it. What was the ruling for that one? That was the one I was confused on.
That's the one where their conclusion, the conclusion in the report is not coming in. All right, and so I'll leave Ms. Wicks to get a hold of you so you can discuss anything in the nature of jury trial for July 15th at 8 o'clock. All right, sir?
All right.
All right. That's all for the record in 2400753. Mr. Strong, you're all set. Thank you for your appearance, and we'll see you on that July date.
We want to do Mr. Chapman. He's been here out for a while, yeah.
Oh, yeah. And sir, you're Shondell. You are Shondell Chapman, is that correct?
Yes, sir.
All right. So we're on the record in docket 2302915. That is People of the State of Michigan versus Shondell Jackson. Will the parties please, Shondell Chapman, will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Chapman, who appears via Polycom.
And sir, once again, you are Shondell Chapman, is that correct?
Yes, sir.
And you can hear me all right, Mr. Chapman?
Yes, sir.
Thank you. This is time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to be requesting a final pre-trial.
Do you need a jury trial with that? I'll leave it to your,
No, not for now.
Okay.
No, I don't think so.
all right, we'll set for final pretrial. And that's a fair statement, Ms. Wickman.
It
We'll
is.
reset for final pretrial, or we'll move to final pretrial on,
July 8th
all right,
at 8:30.
July 8th at 8:30. So, Mr. Chapman, we've reset this, we've moved this to final pretrial on July 8th at 8:30. Ms. Wickman, Ms. Wicks, did you have anything else on 2302915?
No, thank you.
All right, Ms. Wilson.
Not for the people.
All right, Mr. Chapman, we've set it for July 8th at 8:30, and I'll see you live on that date. All right, sir?
All right, would I get just speak to my lawyer or no?
Mr. Chapman, I can set up a meeting with you. I've got a few other hearings I do need to handle here on the record, though.
So she'll set up a meeting with you sometime in the next couple of days. And you can talk about the final pretrial that's been set.
All right, thank you for your time.
All right, thank you, sir. That's all for the record in 2302915.
And I'm ready on Mr. McConnell.
Was Villarreal set for today?
Yes.
I believe so.
Alyssa?
Yeah.
All right, Mr. McConnell, we'll call your case. You can unmute.
Sorry about that, Your Honor.
No, you're all, nope, we just called your case. You're all, so we're on the record in docket 24011577. That is people of the state of Michigan versus Gage McConnell. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. McConnell.
And sir, you are Gage McConnell, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. McConnell?
Yes, Your Honor.
All right, this is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe that we're gonna ask for a final pretrial corresponding jury trial.
And that's a fair statement, Ms. Wicks?
It is.
All right. So we'll set it for final pretrial. So the final pretrial will be live, Mr. McConnell, unless I hear differently from the parties. And that's set for final pretrial on
July 8th at 8:30.
July 8th at 8:30. And then corresponding jury trial.
That'll be 1 second.
That can probably be in August.
Yeah,
Yeah.
it's like I'm gonna go there. We could do July 29th. Actually,
Try July 29th
at 8 a.m.
at 8. All right, so Mr. McConnell, your final pretrial has been set for July 8th at 8:30. Your jury trial has been set for July 28th.
No.
Right. July 29th at 8 a.m. And you should get notice sent to that. Looks like the Foster Avenue address. Is that correct, sir?
I'm not allowed over there, Your Honor. My brother lives there, and I have a no contact order. Against.
All right. Do you
12.
do you have an updated address?
Yep. It's 1209.
All right. Let me update it for the file here.
Yep.
1209.
1209 Cotwood. CAWOOD.
CAWOOD.
Yes, sir.
Okay, and that's Lansing, Michigan.
Yes,
4891. What's the zip code there?
48915.
48915. All right, we have the, so we will update it in our file, but your address is updated at 1209 Kwood, Lansing, Michigan, 48915. Is that correct?
Yes, sir.
All right. Anything else on the record in 24011577, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. McConnell, you're all set. We'll see you on that July 8th at 8:30 date. Okay, sir?
All right. Is that over Zoom or is that in person?
No, that'll be live. That the next two will be live in person. All right, sir?
Okay. Yes, sir.
And that'll be on the 6th floor of City Hall.
All right. Sounds good. Thank you very much, Your Honor.
Thank you.
All right. Bye.
I don't want to put in person or Zoom on somebody.
unmute myself. We're on the record in docket 23-01431 and 23-01432. That is People of the State of Michigan versus William Hill. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Hill, who is seated behind me and to my right.
And sir, you are William Curtis Hill, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial and a motion hearing. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I guess starting with the motion, we've had arguments on this issue on other files. I think we have an inkling on what the court's gonna do.
I would think that, because that involves the
That's the
dog bite statute.
dog bite
Mhm.
statute,
Yeah.
all right. And so I've ruled
Yep.
at least twice on that before. So I'm assuming the same arguments in the same motion. Is that a fair statement, Ms. Sutter?
It is, Your Honor. I'd stand in the previous arguments of the motion.
All right. So I have ruled on that before, that the pursuant to the circuit court's opinion on the making of the ability to promulgate the dog bite statute by animal control uses is under question right now. I know that the prosecutor's office is appealing that to the Court of Appeals. But based on that my review of the opinion, as indicated in previous cases, I will rule the same way. So that means that 1431 would be dismissed pursuant to the opinion.
Yes.
Okay. So, and that would be on the court, that would be on the defense's motion. So we can do a motion of acquittal on that one. And I only say acquittal because it's really not a motion for acquittal, but that's what the code says.
Yeah.
So, so the motion to dismiss is granted based on prior briefs and arguments concerning the dog bite statute. Dismiss is granted. I will sign the motion to that effect. Thank you. So I will sign the Nolly Pross docket 23-01431. Defendant's motion for dismissal is granted without prejudice. On that, with the understanding that that's going up to the Court of Appeals whenever they want to review it. And then in regards to 23-01432, Ms. Wilson.
Thank you, Your Honor. In speaking with Ms. Sutter, it's my understanding that the dog in question has been put down by animal control. The people will be moving to dismiss for compliance.
And that's a fair statement, Ms. Sutter.
It is, Your Honor, and there's no objection.
All right. So is this on a warrant or is this that's it?
I believe it was a complaint, but
Let me see. We'll need another Nolly Pross that you'll sign.
it was on a complaint, Your Honor.
Okay.
Oh, no, I apologize.
Yeah, I
It was
thought
on a
it was a
ticket.
ticket.
This one was on a
Then I
ticket.
can just do it.
Just sent to us like
So we'll dismiss without prejudice on compliance purposes. So, Mr. Hill, this means that I'm going to dismiss without prejudice, which means that people could reissue if they choose to, but realistically, the case is dismissed for our purposes. All right, sir?
Yes, Your Honor.
All right. Anything else for the record in 23-01432, Ms. Wilson?
Not for the people.
Ms. Sutter?
Nothing further.
All right, you're all set, Mr. Hill. Thank you for your appearance today.
Thank you, Your Honor.
Only one. He can.
So we're on the record in docket 24-00013. That is people of the state of Michigan versus Alyssa Villarreal. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Villarreal, who does not appear to be present.
All right, this was scheduled for 8:30. It is now 10:11. It would appear that Ms. Villarreal is not in the Zoom courtroom, physical courtroom, and based on the representations of counsel who's called in the hallway, Ms. Villarreal has failed to appear for the final pretrial today. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. Be requesting a bench warrant.
There's a request for a bench warrant, an immediate bench warrant. Any comment on that, Ms. Wicks?
Your Honor, I would just note for the record that the complaining witnesses in this file are not present either, and therefore the prosecution realistically would not be able to proceed today.
Fair enough. That's true. But Ms. Villarreal should be here, and then all this would go away for her. But I will grant the bench warrant. Anything else for the record in 24-00013, Ms. Wilson?
Not for the people.
Ms. Wicks?
Not for defense.
All right, we're all set on that file. And then, Ms. Sutter, you're here on Van Buren?
Yes, Your Honor.
All right. All right, so we're on the record in docket 23-03288 and 24-01406. That's people of the state of Michigan versus Erica Van Buren. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Van Buren. I do not believe she's present at this time.
All right, this was set for 9 o'clock. It is now 10:13. It would appear that Ms. Van Buren has failed to appear for both files, 23-03288 and 24-01406. They were set for pretrial today. I do not see a Erica Van Buren in the Zoom courtroom, physical courtroom, and based on the representations of counsel, will indicate the defendant has failed to appear. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Be requesting a bench warrant. I believe that this is not Ms. Van Buren's first failure to appear.
Ms. Sutter.
I will leave it to the discretion of the court.
All right, thank you. It would appear that there's a failure to appear on both files out of May 28th of 2024. I'll issue a immediate bench warrant on this file, on both files, 23-03288 and 24-01406. Anything else for the record on either one of those dockets, Ms. Wilson?
Not for the people.
Ms. Sutter?
Nothing further.
All right, thank you. That's all for the record on both of those files. That was Ms. Van Buren. Ms. Piper.
I have also not seen her yet here, Your Honor. I know she was in court a couple of weeks ago based on communication, so I'm not sure as to her non-appearance today.
That was a compliance, right?
Yeah, it was a dog bite motion and several pretrials that were scheduled, I believe, on June 4th that Mr. Foreman appeared for. And I will admit, Your Honor, I was unable to try and contact her last week, which I would normally try and do with clients.
Right.
So I can't explain her non-appearance today, but I did get to remind her the way it go.
All right, so we're on the record in docket 22-01877 and 22-01878. That is people of the state of Michigan versus Jessica Piper. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Piper. She's not currently present.
This is time set for a pretrial on both of these. These are both dog tickets, I think.
Correct.
And then we'd previously adjourned for compliance measures. Ms. Wilson, this was set for 9:30. It is now 10:16. it would appear that the defendant is not in the Zoom courtroom, physical courtroom. So the defendant has failed to appear for the pretrial in the matter. I will indicate for the record that the defendant has previously been here before. There are no bench warrants for the during our hearings. I think there was an arraignment bench warrant, but that's a little different. And that Ms. Sutter was on vacation last week. And so, Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. The only thing that really gives me pause is the age of the file, but I would think it's the court's discretion.
Ms. Sutter.
Thank you, Your Honor. I acknowledge Ms. Wilson's point here. However, I would ask the court to consider possibly resetting this matter 1 to 2 weeks to allow me to get back in contact with her and encourage her to appear at our hearing.
Yeah, because they're dog tickets and there was an adjourn for compliance and then the motion was put on top of that. There may be some confusion. So I'm going to reset this and not issue a bench warrant. We'll just reset
July 15th at 9 a.m.
for July 15th at 9 a.m.
Thank you, Your Honor.
And that'll give you some contact to see if you can get a hold of Ms. Piper. All right, anything else for the record in 22-01-878 or 877, Ms. Wilson?
Not for the people.
Ms. Sutter.
Nothing further. Your
All
Honor.
right, that's all for the record in both of those files. Well, Ms. Ramirez.
I have not seen her this morning, Your Honor. There's no one in the hall.
All right, so we're on the record in docket 1903786. That is People of the State of Michigan versus Amelia Ramirez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Ramirez. I do not believe she's present today.
All right, this was a pretrial set for 9:30. It is now 10:18. I do not see Mr. Ramirez in the Zoom courtroom or physical courtroom. Based on the representations of defense counsel, it would appear that Mr. Ramirez has failed to appear for the pretrial on the matter. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. This is an assaultive offense and there is a prior fail to appear and be requesting a bench warrant.
All right, any comment on that, Ms. Sutter?
Thank you, Your Honor. It appears that in this matter, she was arraigned on June 4th, so it's pretty recent in time. I understand the nature of the allegations here. However, I would ask the court to consider a 48-hour hold on any bench warrant to allow my office to try and get in contact with her.
It's a 19 case. We
It's
lost.
an older case, but she was very recently arraigned on it.
Okay.
I believe this is the first hearing that we would have had.
She was previously arraigned on, according to my notes, September 6th, and then she failed to appear on September 17th, and then she was rearraigned on June 3rd.
I just apologize, Your Honor. Do you have the year of the original arraignment?
2019.
19, okay, so before our office.
Yeah, she was arraigned before your office. She was arraigned, and then she failed to appear 2 days later at the pretrial, and then they picked her up, and she was rearraigned on June 3rd, 2024. So 5 years. I'm going to issue I'll issue an immediate bench warrant in this case, just because of the prior fail to appear and the assaultive nature of the crime. And Mr. Ramirez is well aware that she needs to appear for the case at some point in time, or she'll get picked up again, unfortunately. So I'm going to issue a bench warrant and bond forfeiture. Anything else for the record in 1903786, Ms. Wilson?
Half the people.
Ms. Sutter.
Nothing further.
All right. That's all for the record in 1903786. And
I think that's everyone.